All right. Very good afternoon / evening, everyone. Happy Hump Day. This is the third day of the Singapore Convention Week. Some of us have survived this far. This this seminar is really intended to imagine or reimagine what an effective dispute resolution mechanism would be for commercial disputes of the now, but also of the future. And I'm absolutely thrilled to have the stellar cast with me this evening. Starting from my extreme left, Lawrence Wong, Senior Director of the Singapore International Commercial Court, Ms. Rachel Lee, Head of Litigation for APAC at UBS, Ms. Margaret Ling, Partner at Allen and Gladhill, Ms. Olga Oltenko, Partner at FAMTA, and Mr. Toby Landa, Queen's Counsel, Global Arbitration Rockstar. So let's dive right in. I don't think any discussion of what international dispute resolution could look like would be complete without recognizing and acknowledging, I think, the contributions of the Singapore International Commercial Court to that discussion. Some people have called it an original concept, which I think is a fair description, seeking to combine the best practices of both litigation and arbitration. So on that note, and before we delve into a discussion with the rest of the panelists, I would like to invite Lawrence to spend a few minutes just telling us a little bit about the features of the SICC that make it unique, and in particular to give us, I think, an update of what the SICC has been up to in terms of its recent rule changes. Lawrence,
Thanks, Paul.
thank you.
Thank you. Can we switch that? Yes. Firstly, thank you all for being here, and those online, apologies for a slightly late start. I guess there's a price we pay when there's wine waiting outside while everyone reluctantly comes into the room. So we titled this part of the Convention Week program as International Best Practices. And of course, for this session, we are referring to, at least I'm referring to international best practices in the SICC. And why do I talk a lot about that? Because when we established SICC before, we established it on two substantive principles. One was on international law, and the other was international best practices, international commercial law. So the key thing about the SICC was the Chief Justice thinking at the point in time. One part of it was to actually enhance and enrich the lex mercatoria. What we were finding out was that as time was going on, as you have more and more arbitral awards, your jurisprudence was not growing because your arbitral awards are confidential. So there's no reference point as trade changes, as finance changes and investment disputes happen, and you're not able to see where some of the thinking and the decisions are being made, where those disputes are. So that's how we came about that. But the other key component, as I said, was the ability to adopt international best practices for dispute resolution within the court itself, such that parties who come to the court, and especially the lawyers, will not find themselves unfamiliar, those who are already practicing international arbitration within this court, right? So with that, if I could just move to the, I need some technical help here. I'm pressing the forward button, but, okay. Distinguishing features of the SICC. Of course, the diamond on the left is that disputes must be international commercial nature. But the key thing is we establish a court-based case management system. So to ensure that matters that come before the court will progress in a very regular manner, in an efficient manner forward. And as part of this is also, as you can see from the screen, that we actually pride ourselves on our judge-led case management conferences, right? Which is, again, if you're an IA, you will find it regular, but for those who are familiar with the High Court in Singapore, you will find that the pre-trial conferences are actually managed by registrars first before it comes to the hearing. But over the SICC, we decide that we wanted a judge-led case CMCs. And for those who have appeared regularly before court, including Toby and especially Paul in that sense, he would appreciate how the judges tend to shape the dispute and the issues that need to be heard in the hearing itself. And also, your next distinguishing feature is that of procedures, where you always have the right to appeal within a court, and you avoid party appointing tribunals. In the SICC, for first instance, you could have 1, 2, or 3 judges appointed to hear each dispute. Parties could actually determine ahead of time, the contract stage, if they want, whether they want a 3-judge quorum or a single-judge quorum. But as the case moves, the Chief Justice also has the ultimate right to determine whether, if it's uncomplicated enough, parties may not need a 3-judge quorum, but a single-judge quorum too. But the point is, it's all appointed by the Chief Justice and not by parties, unlike arbitration. However, the Chief Justice has said in public, and because of that, I can quote him, that if parties were to mutually request that perhaps a certain judge could be considered, he would take that into consideration in the appointment of the judge, right? In terms of jurisdictional related disputes, the next distinguishing characteristic of the SICC is the ability to join related parties. Now, there's many disputes nowadays, as you realize, where it's always multi-party, multi-contract situations. It's no longer a situation of A sells to B and B pays A a sum of money, and that's that, right? So when you have such cases, the ability of the court to issue an order for a party to be joined is a much more efficient process, I would say. And you think about it, most times, it's not because parties don't want to be joined. If there's a reason for them to be joined, is that you have the originating parties. One of the parties may refuse to allow a joinder, only because where he's concerned, I'm only dealing with party B, I don't want anyone else involved, get my dispute cleared fast, and you can deal with party B on a separate tribunal or whatever it is, right? So the ability to join and related parties, again, something that is more efficient in the courts. Then what you have is, in terms of enforceability, as you can see down here, that with the SICC being a court of law, you have published judgments, and with the published judgments, you are enriching the jurisprudence, the lex metatoria, such that going forward, where you have similar disputes, disputes of similar nature, it's easier to get parties to sit down and perhaps arrive at settlement rather than go through the whole rigmarole of having to go through trial and establishing things and taking up time and cost again. In terms of specialist judges, we have a diverse panel of Singapore and international jurists. So the SICC is not a Singapore court in that sense, but a court in Singapore where we have judges who are not Singaporeans sitting on the bench. We have lawyers, and I'll reach that point next, who are not registered Singapore bar that's actually able to represent parties in this court. So that choice is always there, party autonomy, party choice, right? And that point, as I said, representation by counsel of choice. So those is what I feel are the distinguishing features of the SICC. Just very quickly, in terms of jurisdiction, we are a division of Singapore High Court, which means that all judgments of the SICC are deemed to be judgments of Superior Court of Law for the purposes of recognition and enforcement in foreign jurisdictions. There's a right of appeal, the Singapore Court of Appeal. Some of you may not know this, but parties can also, if they choose, contract out a right of appeal. Or if it's a hybrid thing, you have 5 issues to be heard. Parties may mutually agree. Issues 1, 2, and 3, one judgment is rendered, no right of appeal, but 4 and 5 may be appealable. So there's that flexibility with there. Jurisdictional requirements, of course, you have to prove that the claims are international and commercial in nature. And the second bullet point there is critical, that parties must agree to submit to jurisdiction of the SICC. Again, similar to international arbitration, we need to establish a nexus for parties to appear before this court, so as you avoid claims of or defenses of foreign non-convenience down the road. Also, the SICC has jurisdictional cases that's transferred from Singapore High Court, of which in the early years, we've had quite a number of cases that commenced in the High Court in Singapore and were transferred to the SICC. And the last point, which has been growing over the last 2 years, especially, is applications under the International Arbitration Act. So you may have arbitration seated in Singapore under SICC Rules or under ICC Rules. And if there's any need to apply for a setting side application, you could come to the SICC instead and have the advantages over there. Quick slide on our international judges. We have 18 international judges now, amongst them 3 former Chief Justices, Beverly McLaughlin, from former Chief Justice of Canada. You have Robert French, the former Chief Justice of Australia, and you have David Neuberger, the former President of the Supreme Court of the United Kingdom. We also have a former head of the Commercial Court of London, Jeremy Cope, head of Technology and Construction Court in London, that's Vivian Ramsey. So amongst them also, there are 2 civil law judges, so that you can hear matters with civil law jurisdiction involvement in there, and that's Dominic Harsher from France, as well as Yuko Miyazaki from Japan. Next slide, please. I mentioned about foreign representation. So parties can be represented by foreign parties in certain cases. The first is what we call offshore cases, where there's no substantial connection with Singapore. In that, foreign lawyers who are registered at court can make full representation on behalf of their parties. The other one is questions of foreign law. So unlike a normal common law court that you know that you need to appoint an expert witness, file an affidavit, be cross-examined in court, with the SICC, if you are lawyers, say, registered in England and Wales, and there's questions of English law involved, you can submit directly to a court and save a lot of time in the process, okay? As long as you're deemed competent in that particular foreign law, you can make submissions. Straightforward application process. We require minimum 5 years of office experience, no disciplinary action, past or pending in your own bar. And the last one is fluency in English because of the language of court. And no, we do not administer English test. Next one, flexibility in procedure. Just very quickly, foreign law, I mentioned that. Rules of evidence, we are quite unique in the sense that even though we are caught in Singapore, by default, Singapore Evidence Act applies, but parties can mutually choose to disapply Singapore Evidence Act and take on another set of rules, of which I think many of you in here are familiar, the IBA rules on taking out evidence in international arbitration, for example, right? And in terms of document production, we also do not practice general discovery. So you produce the documents you intend to rely on, or that you, by an order of court, opposing counsel will to provide to you. So that's the amount of flexibility we have in court. In terms of confidentiality, next slide. While many times people say, oh, I like arbitration because of the confidentiality involved, in the SICC, we are a commercial court, so we are very sensitive to business interests and business needs. So parties may apply for differing levels of confidentiality, records can be sealed, the courtroom could be cleared for part of the hearing, the statements and judgments can be redacted, and if you can prove that you really need it, we can have party name substitution. So you end up with ABC versus XYZ. The 2 key things we need in judgments are what were the facts and what was the applicable law, right? So other than that, there are different levels that you can apply to court for. In terms of cost, the next slide, I'm not going to spend too much time on it, but just look at the rate, the 2 rate words out there, reasonable cost. So again, unlike the High Court in Singapore, where there's something known as Appendix G, that your fees, the cost awards are capped in that sense. Within the SICC, we've moved away from that, and we use the concept of reasonable cost over there. And of course, it depends on the complexity involved in the matter and how far parties actually take things. My next slide is the most recent development where the court is. When we first established the SICC, even though we are deferring procedures from Singapore High Court, we encapsulated all that under what's known as Order 110, or the Rules of Court. But after 6 years, and we started looking at many of the hearings and disputes that we had, we felt it was time to actually spin off a separate set of SICC rules. So now it's nicely encapsulated within our own standalone rules, SICC Rules 2021, but we implemented it with effect from 1st of April this year. And the general principles are there, where expeditious, efficient administration of justice, according to law, procedural flexibility, and what have you. But beyond that, the new element that we introduced this year was that we have 3 default adjudication tracks that parties can sit down at first CMC and agree with the court on. And the one that's new is actually a third track. That's the memorials track. So you could have just basic pleadings, you could have statements, and you could have memorials, and parties have the option to choose that. Next one is we are ADR friendly. So in the past, during the CMCs, the judges would encourage parties to attempt mediation, but there was no quite coercive powers, and we are still not moving towards pure coercive powers. But what we're telling parties here on the 3 bullet points here, to consider possibility of ADR, and if parties still don't want to do it, the court is empowered to make directions for mediation, for example. I think that's the best example that we have. And of course, as part of Singapore, as you all know by now, we're being international matters. I always refer to mediation as SIMC. And the third one is that if one party is found not to have seriously attempted mediation and judgment is against that party, then it becomes a factor in determining costs, finally. So you don't want to do it, fine. You've been asked to do it, you've been encouraged to do it. But since you wanted to go through the whole hearing, well, my cost orders are going to be slightly different in a sense, okay? Because the key thing is everyone talks about time and costs, and as a court, we are quite serious about the fact that if there are other means of reaching settlement, please try that rather than we go through the whole process here. In terms of evidence, we've introduced new rules with regard to witness statements, with regard to expert evidence. Expert evidence requires application to the court and for the court to actually agree. And even when you agree, we are trying to limit it to one expert. Whether parties agree to one, if you can't, maybe the court will decide on the appointment of a particular expert so that you don't waste time again through the whole process, right? And also, in the attempt of making sure that judges, and this one came very much from our civil law judges in the bench, who after a while started complaining because they were not used to a common law system. Why is it that I keep reading the same thing and over again in all the documents that are submitted, right? So now parties are moved to coming up with a single trial bundle, right? So the judges don't have to keep reading the same thing in different statements and in different sets, and to do that. And of course, the last thing is the appeals process. We made it very clear in terms of timing, in terms of what documents required. So all these were done with the attempt, as I come back to our theme again, of international best practices. Next one. Most of you know the other key development within the court was we've actually provided for third-party funding now, and sort of aligning not just us, but Singapore in terms of international arbitration with international practice by providing that. And of course, the latest out of that was conditional fee arrangement. My next slide, please. So you have parties can now work with their counsel to work on things like either win more fee or no win, no fee, or no win, no fee type of less fee type arrangements. But note, it's not contingency arrangements. Okay, it's conditional fee agreements. So slight distinction, but it's there. Then the other thing that we're quite proud of is my next slide, the TIC list that we call it, the Technology, Infrastructure and Construction List. I touched on multi-party, multi-contract situations earlier. We have many complex matters, and especially all that is within technology or infrastructure projects or even construction projects, where you could have 20 parties involved with 60 different contracts, all based on one dispute. So we've looked at it, we've asked practitioners, how do you resolve such things in other international dispute resolution efforts? And we said, okay, you're part of this, and we decided we'll introduce this. So there's a advanced case management conference type procedures. We've even offered, as you can see down here, 2 optional voluntary procedures, whether it's a simplified education process protocol or pre-action protocol that would help parties come to it. I don't want to spend time on the details, but it's all of this available on our website. So in the interest of time, I'd just like to move on. The other thing that has come into play for the SICC recently, and again, I've mentioned this in the summary slide when I started, SICC is supervisory court for IAA matters, right? So since November 2018, jurisdiction has been extended to SICC to hear arbitration matters. So within your contracts, you could actually state arbitration seated in Singapore, SICC Rules, and a secondary clause that says any matters with regard to jurisdiction or setting aside to the SICC to hear this. What are some of the advantages, as you can see down there, that you have possibly access to our international judges to hear this. And many of our international judges are also quite renowned arbitrators for certain specialized fields that some of you might be familiar with in that sense. Two other benefits. One is cost. Again, because we do not follow the Appendix G or the High Court, where if you're lucky today, a half-day hearing could get you maximum about 50,000 Sing in cost awards, whereas in the SICC, it's reasonable cost. And you can go back and look at CBX and another versus CBX and another versus CBZ and others, you'll find that the cost award there was in the region of about 120,000 besides disbursements, right? Speed of proceedings is the other, and in this method I've sort of quoted here, CJM, it took 3 months from application to disposal, but more importantly, the final hearing was on sometime in May. I can't remember dates, but the judgment came out something like 2.5 weeks later, and it was a written judgment. So that's how fast some of the turnaround in terms of the setting aside applications are. So slight caveat, and this one will give me heat on it, but basically on Monday, Minister Shanmugam answered that one from one of the questions on the floor. Registered foreign lawyers, unfortunately, are still not allowed to appear for setting aside applications. You still need a Singapore co-counsel or Singapore instructed counsel to work on that, right? But to quote Minister, he'll look at it again. So just one final point, excuse me, not so much on best practices, but next slide, because many of you always keep asking, oh, New York Convention is 169 jurisdictions, but in terms of enforcement by a court. So one thing I want you to think back is that the New York Convention came about because courts needed a sort of vehicle to recognize arbitral awards back in the days post-World War II, in that sense. Whereas courts have been recognizing money judgments from other foreign courts for a long time, whether it's in terms of common law courts, common law jurisdictions or civil law jurisdictions. Civil law jurisdictions by reciprocity, common law jurisdiction by the 4 simple defenses of whether there's jurisdiction, there was fraud involved in obtaining a judgment, natural justice was accorded, and whether it's against public policy. But the other significant thing that's happened was over the last 4 years is what we call the Standing International Forum of Commercial Courts, or SIFOC for short. Started by Lord Thomas in the United Kingdom, it now has something like 30 countries and 42 courts that have signed a multilateral memorandum on guidance for the enforcement of money judgments, right, in commercial matters. I think the key thing is it's in commercial matters. So it states very clearly what is the documents required and what's the procedure for filing for recognition enforcement in the various courts. And this, again, is a document that's online. You can refer to that. Next slide, please. So very quickly, in a nutshell, what does international best practices in SICC mean? While we are a domestic constituted court as part of Singapore's judicial and legal system, we believe that we have good reputation for neutrality, trustworthiness, and also rule of law, efficient resolution of disputes, and most importantly, control over time and cost. But on the right-hand panel, with international flavor, where we have a diverse panel of international judges, flexible court procedure, and your choice of counsel from anywhere in the world. So as an alternative, and no, we are not in competition with arbitration in a sense, but it's alternative depending on what parties want. So there's a transparency and open proceedings and published judgments as required, the right of appeal, the ability to join third parties, and access to a full set of interim measures, then that's something to consider. And with that, I'll hand it back to Paul. Thanks so much.
Lawrence, for that introduction to the SICC and its features. So with lots of things to chew on, and we're going to try to break this down into various subtopics. But I did just want to tell all of you that if you have any questions that arise out of whatever the panelists are saying in response to questions that are being asked of them, please feel free to raise your hands and ask those questions as and when we go along. I think we want to try to keep this dynamic as much as possible. So first topic I think I want to pick up on is this idea of case management. I think that was a very strong theme that ran through a lot of what the court is trying to do, the SICC is trying to do. And I think that has been a discussion, at least in international arbitration spheres, for a very long time. And yet, I think many of the cases still more or less run the same way in 99% of the cases. At the same time, the nature of the cases, I think, has become more complex, they've become bigger, they involve more contracts, more parties, and the substance of those disputes have also changed over time. You'll start seeing cases that have environmental issues, public policy concerns, arguments over technology, over which many of us lawyers may have very little understanding about. So my first question, which will be to Toby, is does international dispute resolution have the tools to deal with these sorts of disputes nowadays, or is it a question of application from your perspective?
Thank you very much. The short answer is international arbitration has the tools. It has had the tools for years. And for years, we have been meeting in international arbitration conferences in increasingly exotic locations, talking about the same problem, which is we're not using the tools, let's use the tools. This is Groundhog Day on steroids. And for some of us, it's increasing irritation, frankly, because the law, if you look at it, in most countries, look at the model law, look at all the progeny of the model law, you look at international arbitration rules, they all give tribunals all the powers that they need in terms of case management, in terms of procedural flexibility, in terms of creativity, flexibility. This is the nature, the essential nature of arbitration. It's supposed to be flexible. And yet the problem that we have had is an increasing uniformity of process, regardless of the needs of the dispute. Because what tends to happen, and some of us have been ranting about this for years, is that a case will come in to a tribunal, often an arbitrator who's overtrading, too busy, hasn't got time to actually look at the needs of the dispute, presses the print function on their computer, and standard form procedural order number 1 gets churned out and sent to the parties. And the parties, with an equal lack of creativity, possibly thinking this is coming from the tribunal, so we shouldn't question it, falls in line, and the process actually continues on autopilot. And all the inherent potential is lost of flexibility. So to me, this is a crisis in arbitration. And what arbitration may not have woken up to is the alternative, for example, in the SICC, frankly. Because where this leads to is that actually you get a different approach now in the SICC than you, in terms of case management, than you tend to in arbitration.
Olga, I mean, do you see that as a fair observation about international arbitration proceedings? And if so, why do you think that's the case? Is it just apathy on the part of everyone concerned, or is there due process paranoia? I mean, some people have attributed this lack of activity to the fact that people are afraid of being challenged on challenges.
Well, thank you, Paul. And I certainly wouldn't say that I see Toby Landau's comments as unfair or unjustified when it comes to case management in international arbitration. And I do also agree with you, Paul, that despite having a lot of tools, a plethora of tools in international arbitration to facilitate, to speed up the process, we still end up with rather standard international arbitral proceedings. And I do think that we're getting to somewhat of a crisis. I wouldn't be perhaps as dramatic as Toby, but I do view that as something that may be changed and that may improve over time with perhaps the tribunals using the tools that you mentioned, or with parties moving to institutions such as the SICC with more streamlined case management proceedings. But I would also note that it's important when we talk about this, it's important to actually look at what tools we have. And perhaps maybe it's not the problem with the arbitrators who are too lazy and wish to just click the print button and print out procedural order number 1 template. But maybe we need to look at the tools and see whether those tools can be innovated or upgraded to the contemporary reality of arbitration. And I recall that perhaps you mentioned the introductory speech that at every conference, there is inevitably some sort of tool, groundbreaking tool that's being discussed, and that's being discussed for about 10, 15 years. And I remember 10 years ago, we met at the conference where in Singapore, where we discussed this groundbreaking tool called the Kaplan opening, which was meant for the parties to gather at the early stages of the arbitration for perhaps a couple of hours of hearing so as to crystallize the issues in dispute with a view to potentially facilitating the proceedings. And the objective of that wasn't necessarily to reach a summary dismissal mechanism in arbitration, but rather for the tribunal to see what the issues are and for the parties to see maybe they wish to proceed with something. Now, looking at that tool, is that an innovation? Is that a tool that's assisting with case management of international arbitral proceedings? On the one hand, it does, but then on the other hand, it still calls for a hearing where the counsel are meant to prepare and plead their case. And it's unrealistic to expect that at that early hearing, the counsel would have the authority to dismiss some or say we're going to abandon a defense or we're going to abandon a claim so that we can have a more streamlined process. And oftentimes counsel wouldn't have the ability or the authorization instructions to settle at that early stage in the arbitration. So you do have a hearing, but does it reach the objective of case management, facilitating the dispute and potentially early dismissal of the cases? And then the second innovation that I remember we discussed 10 years ago at a conference in Singapore was a read retreat innovation, and that's more perhaps on the tribunal side and something that Toby alluded to. That's to those of you who are not familiar with this tool, that's the proposal that the arbitrators, when they book hearing dates, that they also book 2 or 3 days after the hearing, so that immediately after the hearing, they can sit down with one another, go through the issues in the case as the memory is still fresh, and facilitate the issuance of the award relatively fast. Well, so in that case, we also need to ask ourselves, first of all, is that really an innovation? Scheduling deliberation meetings is probably not a new point in international arbitration. Second of all, does it actually achieve the objective of speeding up the process of issuing the award? Perhaps for some arbitrators it does, but for other arbitrators, and I know I'm alluding to a lot of the comments that we heard this week in Singapore, that, oh, it's wonderful to actually see people and get together and brainstorm and discuss issues for the first time in 3 years. Well, some arbitrators actually function better when they have time of solitude, when they can sit down and have 3 undisturbed days looking at the case file, recalling the hearing, looking at the transcripts, and framing their minds as to what their decision should be, and then they can have a joint deliberation where their views can be exchanged. So if we're looking at the tools, we do need to sort of reassess what we have in our toolbox and see whether perhaps we're unfairly criticizing the tribunals or clicking the print buttons, and maybe we need to innovate the innovations that we discussed 10 years ago and they're still there, not necessarily used to their intended purpose.
So do you have an example of a tool that you think should be reinvented for?
Well, I was thinking about it, and that's specifically on the read retreat. And actually, from what I recall, Paul, you also came up with an innovation named after you. So whoever is interested in that, I encourage you to ask Paul about it. But I was thinking about it, and I do believe that international arbitration, particular decision-making process, is such an intense intellectual activity, then perhaps it's better done the periods of solitude, where the arbitrator needs to have that undisturbed period of time where he's not taken apart by 20 other matters, and he dedicates this time to resolving this particular dispute. So if I may, my claim to posterity, the bulletin for solitude, the new tool in the toolbox.
Which location would that take place in?
As long as it's away from people,
Yeah.
that should be fine.
In the metaverse. Thanks for that. Very thought-provoking. And actually, I think just hearing what Lawrence had to say earlier and the discussion just now, I thought that one of the differences, a simple difference actually between the way in which arbitrations are managed and court cases are managed, is the regularity with which the court versus the tribunal actually checks in on the parties. And I think certainly, and I'm going to ask Margaret to share her experience with the SICC. There are regular points of time in which you are expected to turn up for a case management conference or pre-trial conference, depending on what they're called, where they will check whether the timelines are being obeyed, whether there are any issues the parties want to discuss, etc., etc. And that, I think, creates a dynamism which sometimes I don't find in international arbitration, because you have your first procedural conference, and then you have your perhaps just before the hearing itself, if at all, or if not, then you just turn up for the actual hearing. And in between, there's almost the silence. I mean, people write in for applications and things like that, but it's not quite the same as how the courts manage their cases. So Margaret, I wonder whether you can share your experience with SICC or with courts in general. How are those cases managed, and how have you found them to be helpful, or perhaps not helpful from your experience?
Many thanks, Paul, for the question. I think they're definitely helpful. I think, as Lawrence mentioned, case management conferences before the SICC are judge-led, and I found them extremely useful. So just speaking for personal experience, we have a minority oppression matter before the SICC Kiri and Daista that was commenced in 2015. It had 2 tranches, a liability and valuation stage, and there were multiple appeals. So a quorum of 3 judges was fixed before the SICC. We had Justice Kanan Ramesh, Justice Roger Giles, and Justice Samuel Reyes. And insofar as the international judges couldn't appear in Singapore, couldn't come to Singapore to conduct case management conferences, they would dial in. And it was extremely useful in our case because it took place over many years. There were many tranches. It was helpful to parties to not have to, bring the judges through the entire procedural history or the substantive merits. You could just dive straight into the issues. It was also very helpful to have the judges hearing the actual substantive disputes during the case management conferences. So, for example, very early on, we were given directions on how expert evidence should get used. There was no hot tubbing. It was done by way of expert opinions followed by a joint statement. And just to share another experience as well, there was a satellite litigation that came out of that main minority oppression suit. And the joint venture company had essentially sued our client, the minority shareholder, for breach of contract. And the judge who was fixed to hear this matter was Justice Reyes, one of the judges who heard the minority oppression matter. And again, it was very easy for parties to get directions regularly, and because he was so familiar with the matter. In fact, we were able to come up with the innovative procedural ways of dealing with interlocutory applications. So normally before the Singapore courts, you typically file a specific discovery application by way of a summons, followed by an affidavit, supported by an affidavit, followed by a reply affidavit, followed by written submissions. But in this case, the judge suggested, why don't we just conduct the specific discovery request by way of a written schedule? So that made it so much more easier and circumvented the normal process. So I'm a firm believer in case management conferences before the SICC and they being judge-led.
So I'd just like to add to that. From my experience I've done quite a large number of cases in the SICC alongside a practice in international arbitration. And the practical feeling of appearing in an SICC case management conference is totally different from the feeling you have in an arbitration case management meeting. And to me, there's no reason for that difference in terms of difference in rules.
What's the difference?
And it's a difference because the case management approach, my experience has been in the SICC, is just much more forthright, with the judge being firmer, much more directive, and forcing the parties to come to sensible solutions and imposing solutions where they fail to do so. And the equivalent in arbitration is much more an open discussion. It's more flabby. It's less interventionist on the part of the tribunal. The tribunal may go to a certain limit in suggesting things, but the minute that there's resistance from the parties, they back off. And therefore, they never or rarely get to grips with the dispute in the same way, I think, as in the SICC. So the question I have is, why is there that difference? I don't see a difference in the rules that mandates that, but I do see a difference in mindset. A judge has got a judicial mindset where the judge is in charge, and the tribunal will often have the mindset that they cannot cross a line because of possible challenges. And that's due process paranoia, really, actively, I think.
I mean, that's what people attribute it to, but how real, you've done setting aside challenges.
Yeah.
Do you feel that in any number of safe seats, as it were, that there's actually a real concern?
No, I mean, there was a brilliant article published recently by B.K. Raja on due process paranoia in the Singapore Arbitration Journal, which shows, if you look at it from the point of view of sensible, experienced courts, there is no basis to it, actually. I think the difficulty is that people, they don't always have that in mind. They also don't always know where the enforcing or challenging court will be. If the award is going to possibly be taken to a forum that's less experienced in international arbitration, then you want to play it safe.
Rachel, before we turn to a slightly different topic, I just wanted to give the floor to you to sort of, having heard the lawyers in practice talk about this, from your perspective as a client, what sort of system would you like to see? Would you like to see a system that's perhaps a bit more proactive in managing your cases? Or do you feel like, well, if I choose international arbitration, it's because I want a more consensual approach to how cases are managed? Or would you be happy with a tribunal that's forceful, which is directive, and which takes charge of the case?
Well, thanks for the question, Paul. If I rephrase it differently, which would be, on the one hand, what about due process and the kind of like a case management conferences and pretrial conferences of courts versus the flexibility or efficiency of arbitration, of arbitrations just generally. I think we definitely must strike a balance between the two. And from a client's perspective, my point would be efficiency is of course important to clients, and that's for obvious reasons. But due process is also important because that is what gives certainty to a client in a business environment. And so, just in terms of efficiency, there are many ways of measuring that, and being that time, money, organizational energy, and different clients in different situations would consider these very, very differently too, as between the time, money, and organizational energy in terms of dealing with different cases and different parties for different reasons. So while considering this complexity, I think that one shouldn't really trump the other, but if push comes to shove, from my perspective as a client, given the certainty, I would think that due process should actually prevail over flexibility or efficiency.
Let me just pick up on that point, because I guess one argument would be that they're not necessarily opposed to each other. Toby talked about the attitude of tribunals, right? What's agreed is fine. If there's a disagreement, I stand back. But the fact that the tribunal makes a decision when there is a dispute about the procedure between the parties doesn't necessarily mean that therefore there's a lack of due process. If you've given them the opportunity to be heard and make a ruling that this is how we should proceed, do you have a response? I mean, Olga and Toby, you said as arbitrators, and maybe Branko, it as well. I mean, do you ever feel that you can't make a decision because the parties are dispute about it, and you don't want to risk that being a challenge subsequently?
Well, so that is coming more from counsel perspective, less so than the arbitrator perspective. And counsel specifically working with clients who are very much looking forward to the resolution of certain procedural issues. And as counsel, when you feel and you have to explain every decision, procedural decision that doesn't go in your client's favor, and the client gets quite upset, and you need to demonstrate how you had a good chance, but this has happened. So this isn't necessarily a process. This is essentially a client-driven process where every client would be quite upset if there's a range of procedural decisions that are in favor of the other side. And then, of course, you need to be able to say, well, in that case, we'll send a note saying that we reserve our right to set aside on the basis, and then this is the entire, at least from working with clients, I can say that this is a process that's entirely driven by clients, and they do wish to have the guarantee that they're going to be heard and the due process, and that cannot be trumped by how fast the case is being decided, depending on the nature of the case, of course.
I'd say it's a false dichotomy to say that it's either efficiency or it's due process, or it's either flexibility or it's due process. Due process is a given. Due process is absolutely an obligation throughout, but you have to understand what due process requires. And due process does not require mimicking a court process. It doesn't require going through every single step of an arbitration that often happens if the dispute itself doesn't require that. On the contrary, you may actually end up with an unfair process because people are spending too much money on a huge amount of, let's say, expert evidence, for example, that will never be looked at, that will never matter to the tribunal. Why is that fair? Isn't it fairer then to say, I'm stopping one party from perhaps hijacking this and bringing in loads of material that will never be relevant?
Well, I guess the challenge would be that you don't want to receive it.
No, but that's not right, because if that were right, then tribunals and of course judges would never be able to make any decision. And that's where one comes back to the Kaplan opening, for example, which is an attempt to get over that issue, which is to force tribunals into the detail early on so that they can make that decision.
So I'm going to pick on one particular aspect of this. You've mentioned experts, but witness testimony is also another area which takes a lot of time in the whole process. You've written and spoken about memories and the extent to which recollections are reliable, and therefore I assume by extension whether or not to some extent witness may not be necessary in some cases. And how do you see that playing out in international arbitrations in particular? And I think when we were discussing this point yesterday, you also mentioned that English courts have taken a view on this. I just wanted to see what your perspective was as to how far you think the international arbitration community will adopt perhaps what the English courts have, and maybe just give us a flavor of what the English courts have.
So give you a very brief flavor. What has happened in the last year and a half in the English Commercial Court in London, the Property and Business list, is that they brought in a new practice direction, which is revolutionary on witness statements. And it now puts the English Commercial Court way ahead, in my view, of international arbitration practice. It's a practice direction which I think is 52A, and it's worth looking at if you have nothing else in your life. But you can download it from the net. What it's done is it's recognized that witness statements have become something totally different from what was originally intended by them. Originally, believe it or not, a witness statement was supposed to be a statement of a witness by a witness. And of course, it isn't anymore. It is a submission, and it's heavily lawyered, and it's over-lawyered, and it looks like a memorial. And it's full of things which are not evidence, or things which the witness actually can't really testify to, or commenting on other documents, etc. So just to cut this short, what the practice direction has done now, taking on board also all the learning that's available about the unreliability of recollections and of human memory, is to force people to produce witness statements that are trimmed down just to evidence of that witness, taking out all commentary, taking out all comments on other people's evidence, and explaining how the recollection came about, which is, I mean, as a lawyer, I hate it. But as an arbitrator, I would love it. And that's that the court is demanding it against local opposition, actually, but now it's the case. So in the witness statement for the English Commercial Court now, the witness has got to say, I came to this recollection through the following steps. My lawyer showed me the following list of documents. And on that basis, I have come to this recollection, so that we can then dissect it and understand what the nature of the evidence is. There's much more to say about it, which I won't now for lack of time. But in answer to your question, I hope sincerely that international arbitration and also the SICC will catch up with this, because I think this is one of the real problems in our process, because actually witness evidence dominates international arbitration and it accounts now for a lot of time and cost. And often it's out of proportion to its utility.
Olga, do you see, are you optimistic that the arbitration community will take this up?
Possibly. I mean, there have always been innovations in arbitration to deal with new developments. For instance, during the COVID pandemic, there were so many guidelines, for instance, issued by CIR regarding use of technology. So I am optimistic that they might take guidance from what the English courts have done.
Rachel, what do you think? I mean, you've seen overseas supervised litigation and arbitrations. I mean, in your experience, how much of witness evidence do you think is really necessary? And you know, if the other side were to propose, let's say, you know, we do without witness evidence on certain issues, not necessarily everything, but I think some issues that are obvious, that can be read in the documents, you don't need a witness to talk about them. Would you be open to that as a client, or would you still feel no, I need my witness to be there?
I would love for the courts to go the way that the English courts have, for the reasons that Toby have demonstrated to us earlier. From a client's perspective, that is obviously a good and bad too. Good because it just streamlines the evidence down to the necessary before the court. But also from a client's perspective, especially an organization like a bank, unfortunately, all our witnesses will be able to say would be, we've just been shown these documents by, our in-house lawyers, our external counsel. So it remains to be seen, I suppose, how, that would be beneficial for witnesses from the bank, because clearly throughout the number of years of pendency of an issue, people will have come and gone. And the only records that we have will be based on bank records.
I think that's a great point, particularly from institutions' perspective. Lawrence, are you going to?
No, remember the theme of this international best practices. So we'll take care on that to be in the registry, start looking at the practice direction from commercial courts. Yeah.
So we've achieved something today. I'm going to move on to a slightly different topic, and perhaps picking up a little bit on what Rachel was saying about certainty. Obviously, I think one of the issues with international arbitration is it's all confidential, etc., and so one of the observations about it is that it's very difficult to develop any substantive law, or at least for parties and tribunals and clients to be guided by what the substantive law actually is. And one way, it may not have been the objective of it, but certainly an incidental benefit of the process in England is that because you have appeals on issues of law, file an appeal on an issue of law, that flushes out some of these interesting points, which then becomes a matter of public record. Model law jurisdictions like in Singapore, we don't have that. So I just wanted to have a sense, maybe from Olga and Margaret, whether you think that this is a good idea, that Singapore should perhaps look at this, and then I'll ask Toby what the experience is like in England and whether that has led to unnecessary challenges.
That's a tough one. I mean, as you know, the Ministry of, this is something that the Ministry of Law is looking at. I think there's been some pushback. I mean, the reality is that in Singapore, at least, there have been numerous set aside challenges being filed, and there is a risk that, you know, if this mode of appealing against arbitral awards is allowed, the number of setting asides will increase. And Singapore has made a deliberate decision not to follow the Hong Kong approach of awarding indemnity cost. So yes, there's a real risk of more challenges arising if this other avenue of appeal is introduced.
I think if I may, there doesn't have to be either one or the other. There doesn't have to be either we disallow appeal on the point of law or we completely allow it. For example, in Hong Kong, there is an opt-in mechanism where you actually, perhaps at the stage of drafting the arbitration agreement, the parties can opt into this option of appealing on the point of law. And for certain disputes, for certain transactions, it may actually be beneficial. But for others, there is the need for finality of the awards, and there's the need for credibility and respect for the tribunal's findings on the point of law. So it might not necessarily be a good thing. So with that opt-in mechanism, that could resolve the debate. However, unfortunately, at the stage of drafting the arbitration agreement, it's very rare that the parties would think, well, we've got to choose Hong Kong as a seat, and then we have to look at Schedule 2, Section 5 of the Hong Kong Arbitration Ordinance and include that into the arbitration agreement.
And often the questions of law arise after the dispute has arisen, when lawyers are trying to find ways to challenge it a lot. So what is your experience been like?
So there's been no floodgates. I think you have to look at it historically. Historically, we always had what was called the case stated method, whereby substantive issues could go to the English court. And if you look at Chitty on contract, most of it actually comes from cases that were started in arbitration. So the English commercial and contract law owes pretty much its existence to the ability to take substantive issues from arbitration to court. And that's why there's kind of been this historical fear in England that if we cut this off, our commercial law might dry up. But the reality is that since really 1975, 1979 Act, and then the 1996 Act, appeals on law are extremely rare. In order to get an appeal on a point of law actually before the court, it's got to be firstly only English law, can't be any foreign law. It's got to be where there's been no contracting out. And if you apply any of the modern international arbitration rules to your case, you will have contracted out because the rules will contain a contracting out in them. Plus, you've got to get past a very high threshold where the point's got to be obviously wrong or of general importance. And the result of all of that is that there are very few cases now. But the English Arbitration Act is under review now. The Law Commission is looking at this point, and it is asking, should we now get rid of it? And there's still resistance to that. And I understand the latest intelligence is nothing will change, it will stay. And the reason for that is that there are some industries that actively want it. And they have always been the three industries of commodities, insurance, and maritime. And those are the areas where the market says we want to be able to appeal, especially because of the use of standard form contracts and things which will be, norm setting. And otherwise, most other people contract out. And to me, that seems like a happy balance, really. For those who want it, they have it. Most people contract out.
Rachel, what do you think from I think one of the traditional reasons for banks preferring courts, from my mature-ish point of view, is that there is precedent, and again, like what Toby says, you have a lot of standard forms that you also use quite frequently. So it is helpful to understand or to know what the law is. Do you have a view as to whether Singapore should either have an opt-in, an opt-out, or default as to whether issues of law can be appealed arising from arbitration?
All things being equal, I would say, not only limited to Singapore, I would say, yes, I'm in favor of being able to appeal a decision on issues of law. And I just add that I'm surprised that Toby didn't add a fourth industry. I'm sure this is based on empirical evidence that the banking industry might want that too, to retain that flexibility. And that is only because it is from my perspective, or banks or organizations' perspective, is a risk management. So the ability to appeal is down to the reason, from my perspective, the fact that there remains a risk, however minute, that any arbiter, whether an arbitrator or a judge, even a very respectable and competent one, may still interpret or apply the law wrongly, with due respect to, obviously the many arbitrators and very established professionals here. So yeah, from my perspective, yes, because it is a risk management from my
I just add one point. The reason I didn't add that fourth category is because traditionally in England, banking disputes were never arbitrated for the reason that it was too risky. And banks, the view of banks traditionally was always, look, we're lending money and we want our money back and we don't want to arbitrate. We want to go to court. That's changing now.
Yeah.
But that was the historical position.
There we go.
Yeah.
Yes, yes. So your preference is to have an ability to opt in, or would it be to opt out of an ability to?
Yeah, I think it would be to opt out of it. So the appeal should be as of right, and then the ability to opt out of it. So if I understand the SICC rules correctly, picking on a point that Lawrence also spoke about, is this right of appeal and the extent of it can actually be agreed as between the parties. And I think that is a good balance for a client.
The default is there.
Right.
You can agree to opt out of the right of appeal.
That's right.
Mhm.
Yeah.
And is that because I suppose you're thinking that when you're entering into a contract, the fewer active choices, I guess you have to make, the better, right? And it's only in the very specific cases where you feel you really don't want that risk management option.
Exactly. That's
right. We're going to quickly just move on to the issue of costs, and this may be an area where actually finally arbitration has done a little bit better than the courts, subject save for the SICC. But that is exactly the point that I wanted to get to, because Lawrence, you pointed it out in your presentation that the costs in the SICC is on a reasonable basis. Question is, of course, what that means. And Margaret, I was going to give you an opportunity because I know you have a case that is pending, a 5-judge decision at some stage soon about what exactly reasonable costs means in SICC. So maybe you can just give us a flavor as to what the issue is and how it's panning out.
Absolutely. So the appeal before the court of appeal, before the 5-judge room, will be heard in middle of September, and actually lead counsel arguing the appeal is sitting in the room now. So what had happened was that late last year, the SICC had awarded costs in favor of a client of $4.9 million in legal costs and $3.1 million in disbursements, quite a significant sum. And it was special in the sense that now the appeal is being heard by 5 judges, and typically you cannot appeal cost judgments unless leave is given. And in this case, the Court of Appeal gave leave on the basis that they felt that there were questions of general principle which were decided for the first time and would be to the public advantage to have a judgment on those issues. And those issues in particular, first, what's the meaning of taxation in the SICC? Is it like, the normal High Court proceeding where you submit a detailed bill of costs and the assistant registrar reviews it? Or is it what the SICC says it should be, meaning that costs are decided by the judges themselves, and it just means more than a summary review of the costs claimed by the parties? And the second issue that arose in the case was how exactly do you assess what is reasonable cost? And the court said, no, it's not a matter of looking at Appendix G, which is the normal way as to how High Court proceedings assess their cost. It's really looking at the totality of the matter, and there's only a single attenuation of reasonableness, meaning that you just look at the reasonable of the cost in totality versus the way of assessing cost before the High Court, where there's a double attenuation. First, you look at whether the specific item claimed is reasonable, then you look at whether the quantum claimed is reasonable. And the court said that, cost before the SICC are more akin to cost awarded in arbitration proceedings, but it would not be equivalent to client solicitor cost. So that's one aspect where the SICC is definitely moving towards the arbitration practice.
I don't know. I mean, you would appreciate that for arbitration, the cost recovery is quite different from what it is in the courts at the moment, subject to what I think Margaret has explained. So, do you have a preference as to how the without getting into influencing the courts and all that?
Preference would be to recover as much as possible, clearly.
I think that's the
Yes,
I don't
that's
know if anyone
right.
has a different view.
And to the extent that we're moving in the right direction as to, we're not limited by, a council's PQE or a specified rate that is recoverable, then, that would already be good news for us. And I can, mostly speak about my own experience, having been in Hong Kong for a long time, being previously in private practice and then also in-house counsel. And the recoverability in Hong Kong within the courts, and that's quite abysmal, really. And it's something like 50% if we're using a very good and established law firm, and that is not very good news to my internal stakeholders. And therefore, going back to the point, if we're moving away from very archaic rates, then that is certainly a good thing for organizations like banks.
For the new client, Lawrence. If the decision comes out the way it should. All right. I've just perhaps last few minutes to just spend it on this topic of enforcement, which again Lawrence has kind of foreshadowed. I think many of us who have been involved with whether you're enforcing judgments or whether you're enforcing awards, it's almost like it takes on a second phase of life. And you've got to, in a sense, rerun a lot of the arguments, right? You've got all these defenses that you now have to deal with, whether it's due process, public policy, arbitrability, etc., etc. I guess my broad question to everyone is, has the enforcement mechanism become too cumbersome, whether we're talking about courts or arbitration? And do you think, or do you have any ideas as to how that should be changed or streamlined, simplified, so that someone who wins in the courts when arbitration should, in theory, be able to enforce it in a very short amount of time? You've resisted arbitration.
Actually, I was specializing for a long period of time in defeating the enforcement of arbitration awards, which was I was advertising myself for that. But this is difficult. I think there's a procedural side and there's a substantive side to this. So procedurally, there are courts that are much better than others in terms of the time it takes to get through the process, for example, under the New York Convention. New York Convention allows for a very speedy process, and it can be done where it's done in a number of stages, often where the first one is ex parte, and then you have an opportunity for the other side to come and raise the defenses. So I think that is manageable to make it as efficient as possible. The substantive side is more difficult because people, the question that's raised is, can you, for example, under the New York Convention, go around 170 countries theoretically and raise the same arguments 170 times under Article 5 of the New York Convention to resist recognition and enforcement? And the English court is going some way now to introduce principles of res judicata or issue estoppel, to say that if you've already argued something somewhere, you can't argue it again again and again and again, because you've chosen that you've got a competent court and you've gone to argue it. There are problems with that, and I'll just raise two of them. The first problem is it's not always the same issue. So, for example, public policy in one country won't be public policy in another country. And so the actual test under the Article 5 is not uniform amongst every country. The second problem is a practical one. If you bring in all the principles of issue estoppel or res judicata, you are giving a license to one side to choose its court in order to come to a resolution that will then bind everywhere else. And it may well choose a court that you don't like, and that court may be inexperienced in arbitration. It's a competent court under the New York Convention, but it may be an inappropriate court, and therefore you will get blocked off at that point from 169 other arguments. So I do not have an answer on the substantive side. I think the answer is a procedural one, which is, in your convention is what it is. It's successful, but it can be done very quickly.
I do think that this is a tricky question and a dangerous idea as well, to give away the very valuable right to argue various points under Article 5 and 168 jurisdictions. It's something that I'd be very curious in what Rachel thinks about that, whether that's a right that can be easily given away. But I do, as Toby was speaking, I was thinking about another very popular convention, that's the ICSID convention, where the decision is that the ICSID award is enforceable as if it were a judgment of local courts. And that seems to work quite well as well. So whether that's an avenue for commercial arbitration for the New York Convention and calls for a change, I don't know. I do think it's a dangerous idea. So I'd rather not venture into that.
So I was actually just reading an article, how do you deal with conflicting judgments in enforcement courts?
Yeah.
So, I mean, this author was suggesting that perhaps there could be a sliding scale when it comes to challenges on procedural issues such as there being a breach of natural justice. You know, perhaps there could be a res judicata on that. But when it comes to issues of arbitrability, like Toby mentioned, or public policy, where each state has their own version of what public policy should be, and perhaps, you know, the principle of res judicata or res estoppel shouldn't apply so vigorously or so fully.
Have a perspective on this.
Well, I guess the ease of enforcement is clearly one of the determining factors for you know, a client in terms of choosing between litigation and arbitration. And the fact that an arbitral award is enforceable in 170 jurisdictions or countries, that's very attractive to us. But I suppose that some of the issues I've seen during my time would be actually, despite it being there, the framework, the fact that, you know, the local court's attitude towards enforcement of foreign arbitral awards, what kind of approach would they take? I think that question, and I don't have the answer to this, hasn't actually been front-footed in many instances that I've seen. And therefore, if I may, you know, borrow this opportunity, a request to external counsel would be actually help the clients choose a suitable dispute resolution mechanism, but also front foot this enforcement issues and considerations such that, we're well ahead of these issues even before a judgment or award is won. It may not be answering, any of these questions, but yeah, a small request.
Just in perspective.
Yeah.
You talk to the third-party funders, they actually assess that very clearly before they consider taking on the matter, right? So perhaps maybe counsel could actually do the same too.
Very good point.
Mm.
Very good. I've just got a couple more minutes. Any questions from the floor? These panelists are dying to answer questions.
Other than from Paul.
Yes. I think exhausting. Yes, of course.
It's not so much the sources, but the point is that as we have judgments and all handed down, at least it provides a very clear statement on how the court had arrived at a certain decision and what was applicable law done. And of course, if you go deeper into it, because we're still on a common law basis, you can look at the pleadings and all to see what's put before the court, right? So that we apply the law, whatever whatever is the governing law within the contract. Yeah, so it's not only that because the governing law is Singapore that it comes before the SICC.
If you have a contract that you see coming to that general principle, or like the joint principle,
Yeah.
Or some other form that would be. Have you had that?
No, not at this point in time. Okay.
Now, then the next question is the composition of the court.
Yes.
You have two civil law.
Judges.
Has Dominique Hacher ever sat
Yes.
on one of the, and what was that the case in French law?
Many times. There was one that I mean, you could go back. It's Joseph Agam and another versus BNP Paribas. That's the one that comes to mind.
No,
in the sense that
I'm
it's-
appearing in front of him at the moment. I'm appearing in front of Dominique Hacher at the moment.
And that's French law?
Nope.
Or
Nope, Singapore law and Singapore law, and there are other, but it's not a civil law. It's not a civil law issue. So it's a
Dominique Hacher sits in the case
yes.
of the common law.
So he's sitting. The presiding judge is Justice Ramesh, and with him is Dominique Hacher and Justice Sikri from India.
It doesn't, if I could just expand, it doesn't need to be the fact that there's a civil law component for him to sit on it. But at least on that specific one on BNP Paribas, there were questions on the on Paris land code that at least he himself had a perspective that he could see and sort of shared it with the judges involved. Besides the fact, of course, I think there was expert evidence given on Paris land issues.
Now, any case where the applicable law is other than Singapore, is that treated as foreign law? Or would you decide it as French law or Dutch law or some other?
It would be based on the pleadings and how parties plead their matter and their reference to whichever is applicable law within contract. Okay, so it's not everything is viewed according to Singapore law and decisions made in the Singapore High Court. That's what I'm trying to say.
Where the judge.
And I can just sorry to add, but in answer to I think what you're asking, in the SICC you have an option of treating foreign law by way of expert evidence. There's a traditional version as a foreign, but you also have the option of treating it by way of submission.
That's
Exactly.
So then
Yeah.
the Singapore court would sit as would apply French law
Correct. By way of submission, and that's all sorted out.
on the basis of how I French law would argue.
Correct. That's a big difference. One of the most significant differences with the SICC.
How did it get there?
The jurisdiction clause.
There must be a written jurisdiction clause. It can be a time of contract.
How do you get then, if you don't have Dominic Hacher sitting on the tribunal court, how do you then get to your conviction that that issue, that's what French law provides?
I don't.
Yes. At the end of the day, as I say, it's based on the submissions. It's based on what is put before the court for the court to come to a decision. I wouldn't exactly say that you must be an expert in forget French law. You must be an expert in someone help me out, remote jurisdiction here. And
But practically speaking, so I have another case at the moment.
We have that often.
Yeah,
You see in the case, British law.
yeah.
British law. None of the answers
So
is perfect.
the advantage in the SICC, and I'll be asking for a commission later.
definitely.
I'll give you an example. I have a very big case in the SICC. It's come up for hearing in November, and it's involving Korean law. We have a tribunal, a SICC judges that are constituted with a judge who will know a certain amount. I think a Japanese judge. I can't remember actually. No, not Chinese. I can't remember. But there's a civil law.
Miyazaki.
Yes, maybe.
Yuko Miyazaki.
Yes. But importantly, what we've done is we have agreed with the court that it will be Korean law argued by way of submission, and each side has got admitted a Korean lawyer to do the argument through the registration system.
And we've had lawyers, BVI lawyers too, registered previously for submission on BVI law in other matters. So yes, there's some sometimes when our register of foreign lawyers is actually on site, on our website. And you can see that there's full registration, there's restricted registration. So those that are on restricted registrations would be on various matters actually submitting based on questions of law relating to their jurisdiction.
Korean lawyers will be admitted for the case.
Yes, they need to be registered.
Yes, they be registered, yeah.
Okay.
But he could simply register just the day before the hearing.
No.
Our public statement is 6 weeks turnaround for registration.
If I'm not mistaken as well, there's an application that you need to file an application for leave to submit issues of foreign law by way of submissions as opposed to
Correct.
evidence as
Correct.
well.
But you
Which
can,
come on the CMCs.
you can also register as a foreign lawyer by using the court system, and it's actually quite good. I've registered myself, and it took only 4 weeks by submitting all the required documents. And if a case arises where Russian law issues or Hong Kong law issues are required, then I'll be able to appear, and anyone can apply for that registration.
And it could be a registered lawyer who brings in the Korean lawyer as sort of arguing it as an expert.
Yes, if he's a counsel on record.
To send the application form. All right. Thanks very much for your participation this evening, and to all the panelists. I think it's time for more drinks. Thanks very much.
Thank you.